This screencast lecture introduces you to the legal rules that sometimes excuse contract performance because of a change in circumstances. Impossibility, commercial impracticability, and frustration of purpose fit into a broader group of doctrines that determine what it means to perform and when a promisor might not have to perform at all. You read Stees against Leonard. We've discussed construction bidding in Pavel and accepting a roofing contract in Evertight. This is yet another construction case, one of many collapsing building cases. Take a look at paragraphs 4 through 8 of the court's opinion for a long litany of quicksand, lightning, fire, wind, and other disasters. When I'm feeling a little sorry for myself, these cases sometimes spring to mind. My troubles usually pale in comparison to these construction catastrophes. The problem of collapsing buildings has also caught the attention of the comically creative Monty Python. The facts of Stees, more or less, are recited in a famous scene from the Holy Grail about the King of Swamp Castle. There's a link for your amusement on the additional resources page. All of these cases involve an unforeseen contingency, in this case the condition of the soil. But before we consider whether that contingency might justify excusing performance, I want to call your attention to two arguments that the court didn't permit the defendants to make. In Stees against Leonard, the builders and the owners evidently discovered the soil problem even before the first collapse. According to the builders' offer of proof at trial, the owners promised to keep the soil drained, but then failed to do so. If true, this fact would have allowed the builders to argue that the owner's promise modified the parties' original contract and created a new duty for the owners, which they then breached. Or the builders could claim that they detrimentally relied on this promise, and that the court should enforce it using promissory estoppel doctrine. These arguments were probably the builders' best chance for success, but the Supreme Court of Minnesota upholds the trial court's ruling that excluded this evidence. Why? Please pause the video now to check the opinion and jot down your explanation for this ruling. Did you find the basis for the court's ruling? The reason is that the builders failed to include these facts and this legal argument in their answer to the complaint, as you can see in paragraphs 14 through 20 of the court's opinion. Courts won't consider arguments if they aren't made in a timely fashion. Thus, the builders are undone by a procedural default. Now, modern pleading rules are more relaxed than they were in 1874. So today, the builders might have been able to amend their answer to add these defenses. But even now, you can't raise new arguments on appeal, unless you're challenging the court's jurisdiction to hear the case. This problem illustrates how important it is for you as an attorney to be conscientious and to attend carefully to procedural matters. It's inexcusably bad lawyering to allow your client's claims or defenses to be barred by a procedural default, and doing so may well provoke a suit for legal malpractice. In class, we'll focus on the role that the language of the contract plays in the Stees decision. In preparation for that discussion, you should consider the following questions. What rule does the court announce? According to the court's opinion, what justifies imposing liability on the builder? What could the builders have done to protect themselves against liability? From what source does the court derive the idea that performance should be excused if it's physically impossible? What exactly did the contract require the builders to do? And what happened when the builders tried to construct the building according to the plans and specifications? What does the court suggest that the builders should have done when they discovered the problems with the soil? Was the contract language drafted to memorialize an agreement the parties had negotiated about the risk that the soil was quicksand? And finally, note that the court chides the builders for failing to include language protecting themselves against the risk of bad soil conditions. How could the court have made a symmetrical contract drafting argument about the owners? As we'll see in class, the Stees court's approach doesn't hold up well to close analysis. Our second principal case on excuse, Taylor against Caldwell, adopts a decidedly different jurisprudential approach. Taylor, a performer and promoter, contracted with Caldwell, a booking agent, for the use of the Surrey Gardens and Music Hall on 4 summer days. Before the first concert date, the hall burned down. Taylor sued Caldwell to recover money expended promoting and preparing for the concerts. Presumably, the expected profits from the concerts were too uncertain to recover for this new venture. The court rules that Caldwell doesn't have to perform or pay damages. Both parties are excused from any obligations under the contract. So what's the argument for excuse here? What is the key to the court's reasoning? As you read, the court found an implied condition on the promise. Although this implied condition seems to come out of nowhere, read paragraph 2 carefully for a justification in strikingly modern instrumentalist terms. The court says, there seems little doubt that this implication tends to further the great object of making the legal construction such as to fulfill the intention of those who entered into the contract. For in the course of affairs, men in making such contracts in general would, if it were brought to their minds, say that there should be such a condition. This is the hypothetical bargain analysis, or the majoritarian default, circa 1863. Who knew that law and economics was popular in the 1860s? So there are really 2 levels of legal analysis we can discuss here. First, formal doctrinal categories, and second, attempts to explain and justify these rules in instrumentalist terms. Let's focus for a minute on the formal doctrinal categories. Here's a table that you should be able to fill in based on the cases discussed in our readings. Please pause the video now to find an authority that speaks to each of these fact patterns. Were you able to find answers for all of these situations? First, suppose the performance is physically impossible through no fault of the party seeking excuse. Stees against Leonard implies that physical impossibility excuses performance. What about the death of the promisor in a personal service contract? Hyde against Dean of Windsor, which is cited in paragraph 4 of Taylor against Caldwell, suggests that performance is excused in this case. Suppose that property necessary for performance is destroyed. Well, that's Taylor against Caldwell itself, and the Paradine against Jane hypothetical in the notes in which the house is destroyed. Or Williams against Lloyd in paragraph 9 of Taylor, where the horse dies and the bailee's duty to return it is excused. Or finally, if a farmer contracts to sell his own crop and a flood destroys that crop. In all of these situations, performance is excused. Now, what about a case in which a lessee loses possession or access to leased property? This situation mirrors the holding of Paradine against Jane itself, and the lessee is not excused. How about the destruction of goods after the sale but before delivery? That's the case of Rugg against Minette and the turpentine in paragraph 7 of Taylor. The seller no longer has to deliver, but the buyer must still pay. However, the more modern default rule under the UCC ordinarily makes the risk of loss pass from seller to buyer at the time the goods are delivered, either to the buyer or to a common carrier, whichever the contract specifies. Now suppose that property the seller intended to use to fulfill the contract is destroyed, but the contract doesn't require that specific property. For example, a farmer might agree to sell 10,000 bushels of winter wheat, intending to grow the crop on his own land. But if drought ruins his crop, he can still obtain the wheat on the open market to fulfill his contract. In this case, the loss of the farmer's crop does not excuse performance. This result is a negative implication of the principle announced in Taylor against Caldwell. Courts and attorneys spend most of their time applying these specific formal doctrinal categories to the situations that arise in practice. But it's also worth thinking about the rules themselves from a normative perspective. So what goal do you imagine that courts have in mind? One powerful normative and predictive theory is that courts design default rules to maximize the value of the parties' exchange, to maximize the size of the pie. Courts ordinarily assume that the parties would like to have the biggest possible contractual pie. The parties can then use the contract price to allocate these gains from trade between themselves. So the hypothetical bargain is a useful shorthand for the value-maximizing default term. And notice that the idea of hypothetical bargain was very much a part of judicial decision-making, even in the mid-19th century in Taylor against Caldwell. Far from being a modern innovation of law and economics theorists, this approach has been around for a surprisingly long time. However, modern economic theories allow us to refine the analysis. We can use the comparative advantage criterion to analyze which party is in the best position to bear any particular contractual risk. First, it's convenient to think about any risk as having two components, impact and probability. If this risk materializes, how much will it affect the deal? That's impact. And what are the odds that this particular risk will come to pass? That's probability. We need to ask both questions. It can also be helpful to consider separately which of the parties is best able to assess, avoid, and insure against each risk. The party with better access to information will usually be in a better position to assess the risk. The party who can most cheaply take feasible precautions will ordinarily be in the position to avoid the risk. And the availability of market insurance for specific risks will typically determine who's best able to insure against harms that the parties are unable to prevent.